Good afternoon, ladies and gentlemen. Thank you for your time. Bit of background. I do work with fertility contracts on a daily basis. And I want to give you, as much as possible, information in this next half an hour, how to go about, what pitfalls to look out for, and very importantly, to make sure that your paperwork is done before you embark on this journey. Legal issues around donor cycles. First of all, we've got the National Health Act, and later on we're going to discuss the Children's Act. Those are the two pieces of legislation that is quite relevant with regard to what we're discussing this afternoon. First of all, something that is very important with regards to donation, whether it's embryos, whether it's sperm, and whether it's eggs, is the identity of a donor. So currently it's protected by law, and currently in our system, we know that we've got recommendations. I was part of that task group where we are looking at the possibility of disclosing all the information like in other countries. But currently in our system, Section 41 of the Children's Act is saying, sorry, just bear with me. Where are we? Sorry. Section 41 is saying, access to biographical and medical information concerning genetic parents. 1. A child born as a result of artificial fertilization or surrogacy, or the guardian of such child is entitled to have access to any medical information, and B, any other information concerning that child's genetics parents, and that's after the age of 18. We should keep in mind that this is basic medical information. It's not all the information like in other countries. 2, information disclosed in terms of Section 1 may not reveal the identity of the person whose gamete or gametes were used for such artificial fertilization process. And then the Director General Health or any other person specified by regulation may require a person to receive counselling. So this always happens before a contract is finalised. There should be counselling by somebody in that specific field, and it's usually also by the institution, the fertility expert that's overseeing the process. Section 20. So we've just discussed Section 41. We're moving on to Section 20, and that's parental rights and responsibilities of married fathers. So what is important here with regards to donation of genetic material is that a person who's donating his material for the moment, or hers, but for the moment we're discussing Section 20, so it's male, it's sperm donation. It's important here that we should find out beforehand whether it's known or unknown material, and whether such person, the person donating his material, wants to disclose his identity. So let's have a look at what Section 20 is saying. The biological father of a child has full parental responsibilities and rights in respect of a child. If he is married to the child's mother, or if he was married to the child's mother at time of child's conception, the time of the child's birth, or any time between the child's conception and birth. So that's with regards to a married father or a married male person. If we look at Section 21, we're still on parental rights and responsibilities. The biological father of the child who does not have parental responsibilities and rights of the child, in terms of this section, acquires full parental responsibilities and rights in respect of the child. If at any time of the child's birth, the biological father is living with the mother in a permanent relationship, or if he, regardless of whether he has lived or was living with a mother, consents to be identified or successfully applies. So just for the moment, if I can mention this, if it's a person, a male person, that wants to donate his material, but he relinquishes those rights, he does not have this rights and responsibilities clause contained in his specific donation agreement. But it's important before donation takes place that the male person should declare his will. Otherwise, if he's known and is involved in this child's life, so to speak, he's going to have rights but also responsibilities. And that's where the parental rights and responsibility agreements come into place. So let's just look at 1, 2, and then if regardless of whether he was living or has lived with a mother, consents to be identified, contributes or has attempted in good faith to contribute to the child's upbringing, and contributes or has attempted in good faith to contribute towards expenses in connection with the maintenance of the child. If that's the case, he's going to be liable. There's going to be responsibility for the rest of that child's upbringing. The child will be able to ask or demand for maintenance with regards to the child's upbringing. Now we're moving on to gamete and embryo donation. No withdrawal or transfer of genetic material without confirmation that parties, just general discussion on gamete and embryo donation. No withdrawal or transfer of genetic material without confirmation that parties enter into an agreement. So it's important here, first on the first bullet, to point out that there should be an agreement between the parties with the fertility clinic, but also an inter partes agreement. That's an agreement amongst the parties. The donating party, if that person has a spouse or a life partner, forms part of that agreement, and then the recipient, being a female, usually we'll get to that in a minute, and the recipient's husband or life partner. Because from that flows parental responsibilities. It's important then when we discuss and advise donating parties to declare to what extent this identity and the confidential information should be disclosed. It's possible to have a confidentiality clause that if there's donation, that it's no identity should be disclosed, or that it's disclosed and it's limited information to the closest family, or it's an open fact. It's a donation and your family, but also people around you may be aware of the identity of such person. So that's what sorry, let me just take it back. Oh goodness, sorry about that. Just want to go back one, there we go. Sorry about that. There we go. Identity of parties that we've discussed, and then the medical genetic testing is something to keep in consideration. It's always important that people, when they embark on this journey with fertility treatment, they want to know the sex of such an embryo. Look at the following. Let me just see, genetic testing. Compensation, we'll get to the sex of the embryo in a minute. Compensation first, incomplete commodification, partly gift, partly market. To ensure voluntary and unpaid donations of tissue and cells, donors may receive compensation, which is strictly limited to making good the expenses and inconveniences relating to the donation. So this is part of the regulations of the National Health Act in our country. If you embark on this journey in our country and you've got an egg donor or a sperm donor or even an embryo donation, it's important to keep this in mind because the regulations in our country will regulate such donation. Second bullet, a large proportion of altruistic donors donate to a friend or family member. And then altruistic compensation, we get a lot of questions on this, and it's really a factual question, and then the answers to that is to what extent the donation should be donor should be compensated. So you have to take in consideration a number of things: expenses, out-of-pocket expenses, that person's own personal journey, whether they have a loss of income if they have to travel, and a number of other issues that we consider. So the main factor is it should be altruistic. You cannot do it as a source of income in terms of our regulations. Last bullet, single parents, same-sex couples and heterosexual couples may undergo IVF in our country. So it's possible, even with surrogacy in our country, it's a different topic that we discuss and touch base on tomorrow, but it's still possible to work with donor cycles, and the regulations address it all with all the different scenarios on the last bullet. The sex selection of embryo, Regulation 13 that we've discussed a moment ago. Pre-implantation and prenatal testing for selecting the sex of a child is prohibited except in the case of a serious sex-linked or sex-limited genetic condition. So it's important with this regards to fertility clinics to take this into consideration. Points to ponder. Maximum time period of storage of embryos is 10 years in our country. The ownership of any material that's donated is regulated by Regulation 18. So just for a moment, let's have a look at the practicalities of Regulation 18. Before artificial fertilization, the ownership of a gamete donated for the purpose of artificial fertilization is vested in the case of a male gamete donor, but before recipient of such gamete by the authorized institution to effect artificial fertilization by the authorized institution which removed or withdrew the gamete. So it's important to take cognizance of this. Sometimes there's a time period from donation until the recipient receives the genetic material. For that moment, it vests in the fertility clinic. After receipt of such gamete by the authorized institution that intends to effect artificial fertilization in that institution that we've just discussed or said. B, in the case of a male gamete donor, for the artificial fertilization of his spouse in that male gamete donor before the process or the procedure takes place, and in case of a female gamete donor for the artificial fertilization of a recipient in that female gamete donor. Okay, so thereafter ownership goes to the recipient. So let's have a look at that. After artificial fertilization, the ownership of a zygote or embryo affected by donation of male and female gametes is vested in the case of a male gamete donor in the recipient and in the case of a female donor in the recipient. So in terms of Regulation 18, the recipient is usually, in layman's terms, a person with a uterus. So if we work with a same-sex couple, male same-sex couple, for that period, argument's sake, we work with surrogacy. The donation happens, or rather not, the implantation happens. The recipient is actually the female for that moment, for that cycle, or for that implantation. And thereafter, it will vest in the fertility facility again. Okay, so it's always going to be a female person. So let's take the next factual example before we move on. If it happens that you've got a heterosexual couple, and they've got, whether it's a embryo donation or they've got a male sperm donation or an egg donation, if between the two, the heterosexual couple, they want to proceed, it's important that they also declare their will with regards to that material, so that if in future they do split up or one of the parties pass on, where does that material go? What must happen to the material? Because sometimes you find that you've got donated embryos, there's not an agreement in place. One of the parties, the recipient couple, want to proceed and the other not. Or there may be a legal dispute with regards to this embryo. The one wants the embryo and the other one wants the embryo. Bottom line, with regards to what the regulation is telling us, is the recipient is always a female person. Ethically, it's not possible then to proceed with such an embryo if there's really a legal dispute between the recipient couple. Treatment of couple, disagreement on further medical treatment, or couple splitting up or divorce that we've just discussed. That's why it's important to have an embryo disposition agreement addressing the legalities in such regard. Heterosexual female same-sex couples and single males, we advise them all to have an agreement addressing this specific issue.